if we put all the occurrences across international courts together, then we will say that the more we have the proliferation of courts, the more the success of the rules-based order, the more we are also having cases of non-appearance. Maybe the fragmentation of international law or the proliferation of courts is also a cause for why we're having more cases of non-appearance.
The Inter-American Court has made really strong institutional responses to what has been going on. There's even like an advisory opinion on the withdrawal of the jurisdiction, and there's all this strategic engagement that the court does.
Does your research take this into consideration as a sort of domestic political sphere when jurisdictional arguments and non-appearances become part of the discussion? And do you see courts taking this into account themselves, perhaps by a more cautious reasoning on their jurisdiction?
You could have a state really playing to a domestic gallery. And when the state plays to a domestic gallery and the main concern is the upcoming elections, then that could possibly be another extraneous reason for non-participation before international tribunal.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
Dr. Norman Riat, the founder and convener of the Global South Network's visionary leadership, has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Riat's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
This last question is not so easy, a bit complicated.
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
Good afternoon, everyone. It's my great pleasure to welcome you all to the 18th seminar in Phase 5 of the International Interdisciplinary PhD in Progress weekly seminar series organized by the Global South Network. I would like to start the session with some introductions. I'm Dr. Nouman Riayat, lecturer in law at the Leicester Law School, University of Leicester. I am the founder and the chief convener of the Global South Network, and I have been running these sessions, these PhD in Progress sessions, on weekly basis since March 2023. My research interests lie within the areas of rule of law, judicial independence, judicial politics, constitutionalism in developing democracy. I'm joined by three excellent discussants and one peer commentator. Dr. Arman Sarvarian is the first discussant for today's session. Dr. Sarvarian has been reader in public international law, University of Surrey since 2020, and is a barrister in England and Wales. His recent monograph was about the law of state succession, principles and practice. He regularly advises and acts as counsel to states and investors on a wide range of international law matters. He has acted as counsel to disputing and non-disputing parties in commercial and investor state arbitration. Dr. Melissa Gregg is the second discussant for today's session. Dr. Gregg is a legal associate with Jakub Krasniqi Defense at the Kosovo Specialist Chambers and holds a PhD entitled Courts of Public Opinion, Practitioner Responses to Criticism, Practices Against International Criminal Courts and Tribunals from the School of Criminology at Fraser University, Canada, specializing in international criminal law. Her dissertation focused on the ability of international criminal tribunals to evolve when faced with resistance, critiques, and/or backlash against their work. Dr. Mukarram Ahmed is the third discussant for today's session. Dr. Ahmed is a lecturer in business law at the University of Lancaster and a barrister of Lincoln's Inn. He's a recognized expert and the author of books on private international law and commercial law. He has published in leading law journals, including the Journal of Private International Law and the Juridical Review. His work on asymmetric choice of court agreements and the conflicts of jurisdiction was quoted by the High Court of England and Wales in Etihad Airways versus Flother Air Berlin 2019. His research was also previously cited with approval in the European Court of Justice in many cases, the details of which are available on Dr. Ahmed's online departmental profile. Bruno Rodriguez Levequino is the peer commentator for today's session. Bruno is currently pursuing a PhD in law at the University of Edinburgh. His research focuses on the role of Inter-American Court of Human Rights in shaping multilateralism. With nearly a decade of hands-on experience at the Inter-American Courts of Human Rights, Bruno served as an advisor to 4 different presidents of the court, providing strategic advice on legal, political, and communication issues. Finally, it's my great pleasure to introduce our guest speaker, the main star of the session, for Naphtali Ukamwa, who is a PhD researcher in public international law at School of Law, Trinity College, Dublin. His PhD research focuses on the non-appearance of states before international courts and tribunals. He obtained his LLM from Lund University and Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden, funded under a merit-based Lund University Global Scholarship. He will speak for about 30 to 35 minutes, followed by a 5 to 10 minutes of comments from our discussant and peer commentator. If time permits, we will then open the floor for a 15-minute question and answer session with the audience. Naphtali, we are delighted to have you with us today. The screen is yours.
Thank you very much for the introduction. I just quickly say that today's topic that I'll be presenting, contested jurisdiction, the condition for the non-appearance of respondent states in international judicial proceedings, is a part of my PhD research. So I'll quickly try to lay a foundation for my PhD research. My PhD research inquires into the non-appearance of states before international courts and tribunals and the causes and legal conditions as well as the consequences of non-appearance of states before international courts and tribunals. So today I just look at a section of it. International courts and tribunals in various areas of international law have multiplied over the past decades. They signify the success of the rule-based international order that the founders of the United Nations aimed to establish after the Second World War. International courts and tribunals are central in promoting the rule of law at the international level, which is one of the targets of the Sustainable Development Goals. Developing countries in particular resort to international courts and tribunals to create an equal playing field in their relations with more powerful, typically developed countries. This has most recently been illustrated by the decisions rendered in the two advisory opinions on the legal obligations relating to climate change, which were successfully brought before the International Tribunal for the Law of the Sea and the International Court of Justice at the initiative of small developing island states. International courts and tribunals thus offer an effective forum to broaden and strengthen the participation of developing countries in the institution of global governance. Although recent years have seen a rise in the number and use of international courts and tribunals, this increase has been accompanied by a worrisome trend, state non-appearance before these courts and tribunals. State non-appearance occurs when a state, predominantly a respondent state, refuses to appear before an international court or tribunal, or to defend its case before the relevant court or tribunal. Non-appearances before international courts and tribunals are not new phenomena. Yet, since the beginning of the Cold War, the establishment of the International Court of Justice in 1945 and the post-Cold War period, there has been a renewed surge in waves of non-appearance cases across international courts. One example I gave here is that as of September 2025, the total number of cases in the docket of the International Court of Justice was 201. About 9% of those cases are cases of non-appearance. So what is the legal conditions under which non-appearance occur? Before I state the legal conditions under which, or before I address the legal conditions under which non-appearance occur, I also like to state that there has been non-appearance before the Court of Justice of the European Union. There has been non-appearance cases before the 8 laws, before ad hoc tribunals in investor-state disputes. The African Human Rights Courts, the European Human Rights Courts, the Inter-American Human Rights Courts have also witnessed cases of non-appearance. The Court of Justice of ECOWAS, which is the Economic Community of West African States, have also witnessed a lot of cases of non-appearance. So it goes without doubt that we have been having, or there are cases of non-appearance of states before international courts and tribunals, despite the successes that we have witnessed. Next slide. Non-appearance occurs under the conditions of contested jurisdiction. Non-appearing states have sought to justify their conduct by arguing the so-called manifest lack of jurisdiction of the courts as a basis for their denial or their condition as parties and their obligation to comply with the court's decision in cases of non-appearance. Jurisdictional contests as the main condition under which non-appearance occur is set out in 3 sub-issues: reservation to jurisdiction, withdrawal from jurisdiction, and modification of jurisdiction. For the purpose of time, I'll focus on reservation to jurisdiction and withdrawal from jurisdiction. Modification of jurisdiction is a consequence of both the reservation or relates to both the reservation and withdrawal from jurisdiction. For example, Russia refused to appear in the case initiated by Ukraine. That's the allegation of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide before the International Court of Justice, because Russia believed that the court had no jurisdiction in the matter. Thus, non-appearing respondent state challenges the tribunal's jurisdiction and may thus expect the tribunal not to enter into issues of substance as long as its jurisdiction has not yet been confirmed. In the Aegean Sea Continental Shelf case initiated by Greece against Turkey, the government of Turkey neither appointed an agent nor filed a counter memorial. Government of Turkey sent to the court various documents challenging the jurisdiction of the court. In arguing that the court has no jurisdiction, Turkey pointed to the fact that the reservation in the instrument of accession of Greece to the General Act for the Pacific Settlement of International Disputes of 1928 bars the court from entering or entertaining the case. Turkey also argued that a joint communique between Greece and Turkey cannot be the basis for establishing the jurisdiction of the court. The court upheld the contention of the non-appearing Turkey and found that it has no jurisdiction over the matter. These are the three sub-issues under contested jurisdiction. As I've stated, I'll focus more on reservation and withdrawal from jurisdiction. Reservation to jurisdiction is a condition under which non-appearance can occur with far-reaching legal consequences for the optional clause framework, the bilateral structure of a dispute, the rights and obligations erga omnes, and the rules of jus cogens. The optional clause system under Article 36, Paragraph 2 of the ICJ statutes provide that states may make declaration accepting the compulsory jurisdiction of the ICJ in relation to any other state accepting the same obligation. In practice, when states make such declaration, they often reserve certain matters from the jurisdiction of the court. In the latter situation, a reservation to jurisdiction is said to occur. In the context of a bilateral dispute, a reservation to jurisdiction purports to restructure the original jurisdiction or between the parties to the dispute and the competence of the courts to address the matter. Thus, the jurisdictional basis for the rights of the applicant to bring an action against the respondent state under the optional clause system is contested. The obligations and rights of the respondent to other parties under the optional clause system become even more controversial because a reservation as a reason for non-appearance alters the legal relation between the respondent and other parties accepting compulsory jurisdiction of the court. Indeed, the invocation of peremptory norms cannot serve as the basis for the jurisdiction of an international court. However, a reservation that blocks the access of the applicant state to litigate the violation of peremptory norms creates complication for compulsory jurisdiction once granted under an optional clause system. Respondent states often decided not to appear or defend their case before international courts because they claim that the subject of the disputes and the parties to the disputes are ones to which they had made reservations excluding or limiting the jurisdiction of the court. In this regard, the argument of the non-appearing states can be divided into two. First, non-appearing respondent states argue that the dispute falls outside the dispute to which it has consented to the jurisdiction of the courts. For example, jurisdiction of the International Court of Justice under Article 36(2) of the ICJ statutes. Similar contention exists under the UNCLOS system, where in the detention of 3 Ukrainian naval vessels, Ukraine against Russia, Russia did not participate in the provisional measure hearing, asserting that the tribunal lacked jurisdiction due to its reservation under Article 298 of UNCLOS. Article 298 of UNCLOS deals with instances where a state may make reservation, for example, on ground of sovereignty or military activities. As I take that again, a state may make a reservation excluding certain matters, such as matters involving military activities from being arbitrated or for being litigated. In investor-state disputes, in the Causa Bauxite Company against Jamaica, Jamaica did not appear and was unrepresented, remaining entirely silent on its absence. Meanwhile, before Causa initiated arbitral proceeding, Jamaica notified the center that the jurisdiction of the center will no longer cover legal disputes arising directly out of an investment relating to minerals or other natural resources. However, the tribunal examined its jurisdiction and considered any objection that could have been raised regarding its jurisdiction under Article 41 of the Convention. The tribunal avoided making any decision on the substance of the case and its merits. The tribunal eventually held that it has jurisdiction over the dispute. Another type of form of reservation that states make is that the non-appearing state argues that the party to the dispute is one that it has excluded from those parties with which it can have a dispute under its consent to the compulsory jurisdiction of the court. This is the example of the Nicaragua against US, under which US argued that it has reserved certain matters from the jurisdiction of the court under Article 36(2) of the ICJ statute. While the legal significance of these reservations to jurisdiction is self-evident, it is less examined in the context of their justification for non-appearance. Such reservations complicate matters not just because they specify conditions under which the reserving and non-appearing respondent state will submit to the jurisdiction of the court, but also they are made before or during the pendency of the dispute in which the reserving and non-appearing state has refused to appear. This position raises questions about the validity and consistency of the reservation with the object and purpose of the statute of the court vis-a-vis the applicant state and in relation to other parties to the statutes of the court. In such non-appearance cases, reservations in the acceptance of compulsory jurisdictions are wrongly used to limit the functioning of the court, especially when a non-appearing respondent state claims to reserve its rights in respect of any decision by the courts concerning the claims of the applicant. There are at least 3 implications that follow a reservation to compulsory jurisdiction where it is invoked as a condition for non-appearance. First, reservation to jurisdiction allow the reserving and non-appearing state to define the scope of the jurisdictional obligation and rights. This approach raises a question of the extent to which a unilateral reservation on jurisdiction by the non-appearing state creates, on the one hand, legal implications for the bilateral relation with the applicant, and on the other hand, erga omnes effect of modifying consent to jurisdiction given and obtained under an optional clause system. In such instances, respondent states have pleaded at least 3 grounds for limiting their jurisdictional obligations and thereby justifying their non-appearance. First, they plead domestic jurisdiction to limit or restrict the jurisdiction of the relevant international court or tribunal. These occur through self-judging reservation in which the non-appearing state alleges that it reserves the right to determine which matter may be litigated. The self-judging reservation may be of a low or high degree of discretion of the reserving state. It is of low degree where it simply states that matters such as national interests are reserved, and it is of high degree where it states that domestic issues are reserved as determined by the reserving state. The latter example is the Connally reservation of the United States, where it says that the domestic issues are reserved as determined by the United States. Second, such reservation may take the form of a multilateral treaty reservation in which the non-appearing state argues that the matter is such that it's as excluded from the jurisdiction of the court under its optional declaration, which indicates the exclusion of disputes arising from multilateral treaties subject to the participation of all concerned states, or that the state making the declaration specifically waives such limitation. This was the approach of the United States in the military and paramilitary activities in and against Nicaragua against the United States of America. Third, the declarant and non-appearing states have excluded matters from the jurisdiction of the court that are the subject of determination in other courts or tribunals. I refer again to the same case, Nicaragua against the United States of America. The second implication that follows a reservation to jurisdiction where it is invoked as the condition for non-appearance is that reservations are generally made before the initiation of a proceeding in which the non-appearance of the respondent state occurred. An example is the reservation of Russia under the UNCLOS Article 298 in the case detention of 3 Ukrainian naval vessels, Ukraine against Russia. The United States adopted this approach in the same Nicaragua case. This situation raised consequential questions about whether it is valid and permissible for a non-appearing respondent state to unilaterally terminate or modify existing jurisdiction during an ongoing judicial proceedings. In the instant situation, non-appearing respondents struggle to make a coherent justification for non-appearance when their non-appearance occurred before a valid reservation is made. The third implication that follows a reservation to compulsory jurisdiction, where it is invoked as the condition for non-appearance, is that the extent of the implication of a reservation to compulsory jurisdiction remains unsettled where the non-appearance occurs in a case addressing jus cogens issues. The question that arises in this latter instance is the validity of the reservation of the non-appearing respondent states to jurisdiction where the reservation hinders the access of the applicant to litigate the violation of jus cogens norms. A valid reservation to jurisdiction or certain matters, or even withdrawal from jurisdiction, creates immunity from jurisdiction of the relevant international court. In this instance, there is no jurisdiction as the court or tribunal has no competence over the dispute, and no jurisdictional relation of right and obligation exists between the parties establishing the duty of the respondent to appear. However, the timing of the reservation is crucial. It must have been made before the application was initiated. Where the reservation occurs after the initiation of the case, it is a means to evade the obligation to appear. I quickly touch on state withdrawal. Respondent states have refused to appear under the condition of a withdrawn consent to jurisdiction. This may occur under different circumstances, such as a result of an adverse decision at an earlier phase of the proceeding, such as the non-appearance of the United States at the merit phase after an adverse decision on jurisdiction and admissibility in the Nicaragua against United States. Iran refused to participate and then withdrew its declaration accepting compulsory jurisdiction of the ICJ in the Anglo-Iranian case, UK against Iran, after an adverse decision at the provisional measure stage. After Palestine has filed a case against the United States before the ICJ under the Vienna Convention on Diplomatic Relations protocol, the US withdrew from the VCDR protocol. The case was filed on the 28th September 2018, and the notification of the US withdrawal was received on the 12th October 2028. The US did not appear in the meeting with the president of the ICJ in this case. The issue of withdrawal from jurisdiction arose in Leon Mugesera and Rwanda before the African Court of Human Rights. In that case, Rwanda purported to have withdrawn its declaration accepting the jurisdiction of the court. However, the court noted that the declaration of withdrawal by Rwanda was made after the application had been brought before the court. According to the court, since the application was filed on the 28th February 2017, the court rejected the subsequent declaration of withdrawal by Rwanda, which can only take effect on 1st of March 2017. The implication is that the declaration does not terminate the jurisdictional relation that binds Rwanda to appear before the court. For this purpose, the court proceeded in the absence of Rwanda. A valid withdrawal from jurisdiction creates a immunity from jurisdiction of the relevant court or tribunal. In the instances of a valid withdrawal from jurisdiction, the implication is to divest the court of its jurisdiction in relation to the withdrawing state. In such instances, the court or tribunal has no competence over the dispute and no jurisdictional relation of right and obligation exists between the parties, establishing the duty of the respondent states to appear as discussed so far. The next slide. So in summary, we have seen that the non-appearance of states have occurred because the state not appearing contests the jurisdiction of the court, either because it has made reservation to the jurisdiction before the case or during the pendency of the case, or where such reservation tries to modify the jurisdiction of the court, or that it has made withdrawal from the jurisdiction of the court, where such withdrawal is also an attempt to modify the jurisdiction of the court. Since we've been talking about jurisdiction, it is important to then state the fact that it is the court that has the jurisdiction to determine its jurisdiction. So, for example, Article 36, paragraph 6 of the ICJ statute states that the court has the competence to determine its competence. So, in non-appearance cases, according to Article 53 of the ICJ statute, whenever a party refuses to appear or defend its case, the court will ensure first that it has jurisdiction over the matter and that the case of the applicant is well-founded in fact and in law. The question of jurisdiction is therefore the question for the court to determine. So from the discussion so far, what we see is that non-appearing states tries to step into the shoes of the court to determine that they do not have that the court does not have jurisdiction. I quickly state here that when non-appearance occurs before an international court or tribunal, the court or tribunal has an obligation to satisfy itself that it has jurisdiction, with its regular rules on jurisdiction, before addressing the merits of the case. Since it is the duty of the court to determine its own jurisdiction, or since it is within the competence of the court to determine its own jurisdiction, what is therefore the threshold for determining jurisdiction in non-appearance cases? The threshold for determining jurisdiction in non-appearance cases is a prima facie test. The prima facie test under which the court adopts its jurisdiction is to the effect that the court has only to take into account all the elements before it, including those supplied by extra procedural communications from the respondent, for the purpose of satisfying itself that it has jurisdiction. Quality and type of evidence required to establish a prima facie jurisdiction may take any form, provided they are sufficient to establish that the court or tribunal on the face of the case is competent to exert its jurisdiction. On this note, I'll conclude here and I'll look forward to your comments and the discussion. Thank you for your attention.
Thank you, Naphtali, for an excellent presentation. Really enjoyed the discussion. Melissa, Gregg, over to you, Melissa.
Thank you very much. And thank you, Naphtali, for a really clear and stimulating presentation. For the purposes of transparency, I work more in the international criminal law space. So this was a great reintroduction for me back into the PIL, ICJ case law. And I really liked the way you broke down the three sub-issues and gave us a much more structured vocabulary for thinking about non-appearance. So I want to try and pick up on two aspects that you raised. Perhaps they're covered elsewhere in your dissertation. I know you said this is just a slice. But the first thing I want to pick up on is how far your framework can travel across different courts and tribunals. So in your presentation and in your slides, you've mentioned this very wide range of bodies. So ICJ, ITLOS, investor state tribunals and regional human rights courts. And I really appreciate your comparative ambition, but there's also presumably quite a lot of variation in there. So do reservations, withdrawal and modification play the same role in ICJ practice as they would in an investment arbitration or regional human rights litigation process? Or is it the case that design features like compulsory jurisdiction in certain systems or standing rules that might allow individuals or investors to seize tribunals directly, would these sort of dampen or reconfigure jurisdictional contestation as you describe it? So I would find it quite interesting to hear a little bit more from you about whether your case studies would suggest this sort of three-part framework would work best for specific institutional families, or if there would need to be qualification across the different spectrum of courts that you are analysing. And then my second question is kind of more of a political one, a politics of law one, because non-appearance can also have a really key, as I see it, domestic function, because even the talk of non-appearance has a way of signaling domestic resistance, absorbing anger, or insulating governments from accusations of having, quote unquote, lost before an international court, which is a bit apart from their doctrinal effects. So does your research take this into consideration as a sort of domestic political sphere when jurisdictional arguments and non-appearances become part of the discussion? And do you see courts taking this into account themselves, perhaps by a more cautious reasoning on their jurisdiction, to avoid fueling large-scale backlash that might result in systematic withdrawals or more ongoing rates of non-appearance? And then my last, I guess, question that I wanted to look at is the status of the three sub-issues in your framework. You've presented them as this sort of the key, the withdrawals, reservations, modification, the key ways in which jurisdiction can be contested. For you, is this triad exhaustive, or is it a slice of a broader analytical universe? And again, I could be getting outside the scope of the PIL experts in the room, but I just wanted to get your thoughts on that. But thank you so much. It was a really, really interesting presentation, and I learned a lot.
Thank you. Thank you very much, Dr. Gregg, for your very insightful feedback. Now, allow me to invite our next discussant, Dr. Mukarram Ahmed.
Yes.
Over to you, please.
Thank you very much for an interesting presentation, Naphtali. I am an expert in private international law, not public international law. So my comments may be of a more general nature than the comments of the previous speakers, discussants. You have used the word condition, that jurisdictional contestation is the condition for respondent states and their non-appearance. Now, would it not be more appropriate to use the word primary cause or a principal driver when it comes to jurisdictional contestation as the primary driver or determinant of the non-appearance of respondent states? That's just one point on terminology, because of course in academic legal writing you have to be both precise and concise. Also, in terms of general methodology, you have mentioned that you've relied on doctrinal legal methodology in the presentation and the abstract. Would it not also help to have a comparative legal methodology in addition to a doctrinal legal methodology over here? You are dealing with a number of international courts and tribunals. And of course, when you get to the analysis, that will involve a comparison of how each of these courts or tribunals deal with jurisdictional issues when it comes to non-appearance of respondent states before the tribunals or courts. So, because essentially it is your methodology, may that be doctrinal or comparative, that will get you from your research question, and you will test your research question by an appropriate methodology to get to your contributions of knowledge. So that is essential that you get the methodology, and you should have an appropriate methodology. One other point that I did notice in your presentation was that your focus is on jurisdictional contestation as an explanation or the main explanation for non-appearance of respondent states before these international courts or tribunals. Is it not the case that there are other reasons? Because we're dealing with a broader perspective, and in that broader perspective, there could be concerns regarding the political legitimacy of an international court or tribunal. Yes, let's say the ICC, but there could be an issue regarding the political legitimacy of the forum. There could be issues of power asymmetry between the states involved. There could be concerns regarding the enforcement of the ultimate decision, because remember, jurisdictional concerns are important, but ultimately there will be concerns regarding the enforcement of the ultimate decision from the international tribunal court or arbitral tribunal, let's say. And as was mentioned by another discussant, I think it was Melissa, that domestic politics is also an issue. And you could have a state really playing to a domestic gallery. And when the state plays to a domestic gallery, and the main concern is the upcoming elections, then that could possibly be another extraneous reason for non-participation before international tribunal. And I have a question for you, which is, when a respondent state does not participate in proceedings before an international court, tribunal, arbitral tribunal, and there's a default of appearance, what special measures should be taken by the International Court or Tribunal to ensure the legitimacy of the proceedings? And there's also another question that I have. You mentioned towards the end of your presentation that the standard of jurisdiction is a prima facie test. What does a prima facie test mean? What do you think a prima facie test means in practice? Is it the standard of a good arguable case, as in civil proceedings? When you have international civil and commercial litigation, we look at the standard of a good arguable case. So that really is something to look at. And what sort of evidence would be required for a prima facie test standard? Because in some private international law conventions of the Hague Conference, the prima facie test is used. But what does it mean in practice? And I would ask you that. Yes. That's all from my side.
Thank you, Dr. Ahmed, for your comments. Now allow me to invite our peer commentator, Bruno. Over to you.
Yes, thank you very much. And it was nice to see you again, Naphtali, at least virtually. So my question is similar to Melissa's. So it's particularly regarding how your framework is applicable across different jurisdictions. Because, I mean, and apologies for bringing you to my own area, which is regional human rights courts, and especially the Inter-American system. Because I actually think that the Inter-American Court could serve as a very interesting laboratory to test your framework, because, you know, like it has had it all, like the withdrawal of the jurisdiction, the non-appearance, the participation for the purposes of like contesting the jurisdiction. You have the Nicaragua cases, but also like the Venezuelan cases. And the Inter-American Court has made really strong institutional responses to what has been going on. There's even like an advisory opinion on the withdrawal of the jurisdiction, and there's all this strategic engagement that the court does. So I was thinking, like, I mean, if you have considered like whether this kind of judicial response could serve as a model to be replicable to other international jurisdiction, or is it just like a unique way of responding to that? And just another question is like, how much are you thinking about like authority and legitimacy in your framework? Because I mean, it's something that is like comes across, but maybe if you focus too much on authority, and that's something that happens also in my research that has to deal with international courts. One can be lost in authority and legitimacy and just like, you know, focus too much on that. And I was thinking also, like, and that's just the third question and the final one, if you have considered like not only framing your research on international public law, because I know you are also considering like international private law institutions in the sense that you're like dealing with other mechanisms, but trying to other frameworks such as global law, for instance, or there's now like planetary law discussions. I don't know if opening this discussion and thinking more like not only like in international public law framework would be interesting. But I think it's a really interesting research. So thank you very much.
Thank you, Bruno. Excellent comments. Naphtali, all said, all done. So you received feedback from different areas of law. I just want to highlight, you know, this. We are here to support you. All feedback is for yours, you know, aimed at supporting your research. Thank you very much. Over to you, please.
Some of the comments that are made, I take them as comments to improve my work, but I'll just touch on some of them. In terms of definition, that's from Dr. Arman. I consider that. There's a section in my work where I define non-appearance, and that's in chapter 2 of it. It's a very difficult thing to do, defining non-appearance, because so that's a very valid one. In terms of the percentage of cases, I still think that the ICJ has a high number of cases of non-appearance, because between 1945 and 2025, we have about 9% of non-appearance instances. If we go by all the different shades and variation of it. And I think the ICJ is the only court that has that number. Other courts, we can still say they have a high number of occurrences. But if we put all the occurrences across international courts together, then we will say that the more we have the proliferation of courts, the more the success of the rules-based order, the more we are also having cases of non-appearance. Maybe the fragmentation of international law or the proliferation of courts is also a cause for why we're having more cases of non-appearance. So in that context, I take all the suggestions that you have made, and I also try to classify non-appearance into whether it becomes a question of inability to appear, or it becomes a question of refusal to appear where it is determined. So in that context, I did a lot of definitional problem. It's not easy to come about that, but I'm so happy when you mentioned that. The rest of the factors, you mentioned I think Melissa also mentioned things relating to domestic aspect. Yes, I considered that, and that also relates to the question raised whether I have considered the causes and the conditions of non-appearance. So I try to differentiate between what is the causes of non-appearance and what are the conditions under which it occurs. So that's why I said this presentation is a section within a section. For example, special circumstances of domestic political nature preventing the normal functioning of a state agency is a cause for non-appearance, which the tribunal has mentioned in Benvenuti against the people of the Republic of Congo, where it says that due to certain domestic issues happening in the country at the time, the court actually accepted that, but the court still proceeded with, still continued with the proceedings. So in that context, I differentiate between the causes of non-appearance. I said the causes are the reasons why the state did not appear. The conditions is the general background, the situational context why the state did not appear. So in that context, that is where I then bring out the issue of jurisdiction as a stand alone. In context of whether how far my framework can travel, my framework can travel across all international courts because the subject and object of discussion is the non-appearance of respondent states. So I focus on respondent state across all these courts. So if you check this, the non-appearing party there, they've all been states not appearing in all the cases I've mentioned. So the fact that it's the respondent, in fact, I was tempted to make a theory that all cases of non-appearance in international law, most like in international, before international courts and tribunals, are likely the non-appearance of the respondent state, whether it is before a human rights court, whether it is an investor state dispute, or all these different kind of disputes. They've been, but I did not discuss non-appearance before of the accused person before international criminal tribunals. That way, my framework cannot travel to the international criminal tribunals. And yes, I take the question on the comments on methodology. While I was describing that I used doctrinal method, I stated that it's also comparative since we are using different courts across the cases court across the different courts. But I'll also give that more discussion. In terms of a prima facie jurisdiction, the court does not necessarily have to go into the test. Is very simple, or I think it's like the easiest way of determining jurisdiction on the face of it, whether there is any document on the face of it that the court can establish its jurisdiction. In that case, in that context, the court can establish its jurisdiction on the face of an instrument apparently valid and enforced, purporting to confer jurisdiction on it. So generally, yes, the question you raised about whether I have considered power asymmetry, yes, I considered all those factors. But since my work is doctrinal, I focus on the law as it is. What can I find from the cases themselves? What have states pleaded as the reasons for their non-appearance? States have pleaded force majeure, for example, the outbreak of the Second World War is the reason why Bulgaria did not appear. So that's in itself, the states have pleaded it. And then, so I try as much as possible to focus on what the case law says, as opposed to what one could speculate. In that context, I focus on what can be reasonably inferred, reasonable inference, what we can reasonably infer from the cases as the causes and conditions of under which non-appearance occur, as opposed to just a general discussion on reasons. That way I can try to be more modest without having to go too deep into. Yes, I consider authority and legitimacy of the court, but that I considered in the chapter that deals with consequences of non-appearance, whether it affects the validity of the decision of the court itself. And instances like that, the court have said that the non-appearance of a state does not affect the validity of its decision. The non-appearing state is a party to the case, and the case is binding on the non-appearing state. Whether the three sub-issues I've mentioned are exhaustive, I cannot say they are exhaustive. I can only say they are samples to demonstrate a contested jurisdiction. And whether there could be, there may be other shades of jurisdictional contest. So I still have to, for that question, I will have to investigate further. Maybe I can find something something that I have not given consideration. I think I've tried to answer all the questions as much as I can, and I took note of a lot of all that has been said, and the instances of mutual meeting of minds. I really appreciate your comments. I'll take them into further consideration as I prepare the final draft of the work. Thank you very much.
Thanks, Naphtali, for responding to the comments. Thank you very much. Now, we are already out of time, but is there any comment? I can pick one comment or question from our audience, if there is any. Any comment, any questions? Please feel free to switch on the mic and camera and straight away ask the question. All right, in that case, allow me to conclude the session. So thank you, Naphtali, for excellent presentation. I must say it's very relevant, timely, given whatever is going on at the international level. Engagement with the courts usually absorbs that intensity and tension. And if states stop appearing before the courts, then the tension and the friction goes elsewhere, and it expresses in different conflicts, which we can already see. So having this said, thank you, Dr. Arman Sarvarian, for very useful comments, the comparative insight. I can clearly see the direct relevance of those comments to the ongoing research of Naphtali. Dr. Melissa Gregg, thank you very much for your outward, inward perspective on the project. Dr. Mukarram Ahmed, thank you very much for the very interdisciplinary UK combination of UK-EU perspective. I hope Naphtali is going to find it very useful. Bruno, thank you very much. The Global South Network warmly welcomes PhD project, PhD candidates to present their projects from any discipline, any part of the world, to receive interdisciplinary feedback. If you wish to present or anyone want to participate in any capacity, feel free to get in touch. The email address leicgsn@gmail.com. Same time next week, let's meet our next guest speaker. The details of the project will be communicated to you through a weekly newsletter. Until then, look after yourself. Have a great day. Bye-bye.